You know what's wild? There's a Delaware Supreme Court case from the late 1970s, Quick Check Realty versus Board of Adjustment in Newcastle County. And it's still the law that every zoning board in the state has to follow. And here's what it says in plain English. You can't just ask for a variance because you want to make more money or squeeze more buildings. A variance is only legal if there's an exceptional practical difficulty, something unique about the land itself that makes it impossible to use within the zoning rules. And the court was crystal clear. If you create your own problem, that's a self-created hardship and you don't get a pass. Now, fast forward to today. In Milford, 609 North Walnut Street, across from the Armory, a developer wants to chop up 1.5 acres of R2 zone land into 8 lots, 6 of them semi-detached when the code clearly says the minimum lot width must be 80 feet. They're asking to shrink one down to 56 feet, nearly 30% smaller than the law allows. That's not a hardship, that's a design choice. Nothing stops them from building code compliant single family homes on that same property. They just want more units. And that's not a valid reason. So when the Board of Adjustment meets on October 9th at 10 a.m., Thursday, remember this, the law isn't about what a developer prefers. It's about protecting the community from zoning that gets rewritten one variance at a time. Milford deserves consistency, not loopholes disguised as practical difficulties. Because if every builder can just make up a hardship, we don't have zoning anymore. We just have whoever can afford to ask for forgiveness instead of permission.